a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, indeed, that is that time of the week, and David Whiting has joined us to take all your questions on the legal front. 1300 222 774 is the number. David, good morning.
Good morning, Owen.
We thought we might have a little chat, didn't we, about a story that we covered on the program yesterday, and that is a call for our legislation to be degendered. Is that the right way to put it?
Yeah, I think that's right. If you think about lots of the legislation that we look at, it was written 100 years ago and played with since then. And I think you said before, in 1985, the government decided that we'd endeavour for all future legislation to be gender neutral. And one would come along and think, well, here we are, nearly 40 years later. It would be time to now go backwards and pick up the bits you missed on the way through.
A couple of people yesterday did text saying, why does it matter? Haven't we got more important things? But in actual fact, I think, I read a couple of acts yesterday, and in this Crime Act, there's the Sales Act, where it actually is important, isn't it, when the entire person who is the centre of the legislation or the focus of the legislation is assumed to be a he. It's always he, him.
Yeah, but I can remember, we assumed gender-specific roles for lots of people. So it's exactly that. So the answer was, if we consciously ungender specific, I think we're getting where we need to get to.
Would it be an incredibly complicated and expensive process, or could you use an algorithm to go through all the legislation and change he to they or whatever is chosen?
The process, it would not. Well, you could do what's called an omnibus act, which had the effect of changing them all. But if you really cared about the law, what you would do is you would go and look at every iteration to see if it worked the way you intended. So that's where the hard bits come.
That's a big job.
Yes, well, you couldn't come along and say, well, we're just now going to use an algorithm and he or she becomes them or they.
Because it could have unintended consequences.
Yeah, absolutely. Yes, the law of unintended consequences.
Indeed,
which is gender neutral logically. Yep.
But it's really important. It's a very important issue. David Whiting will take all your questions. 1300 222 774, and we'll kick off with Maria in Chadstone. Hi, Maria.
Hi, good morning. I'm just inquiring about what stamp duties or transfer fees or any other fees or taxes or whatever, if two people were to separate and they were dividing their assets, their properties.
The last time I looked, Maria, and it might have changed, that there was no duty on a transfer as a consequence of a breakdown of a relationship. Now there used to be no stamp duty in transfers between spouses, and then they changed that only to circumstances where it was going to be the principal, where it was going to be the residence of the transferee. Now you'd need to look. What you're really doing though is you're saving the capital gains tax issue as well, because if there's a court order in the breakdown of the relationship, then it doesn't trigger capital gains.
Right, okay, unless you sell it.
Well, if you sell it,
yeah.
In the normal course, if you were to transfer a property to somebody, that would trigger a disposal for capital gains tax purposes, but a transfer between parties to a relationship where there's a court order doesn't trigger that bill or that expense.
Right.
My recollection is that stamp duty on the breakdown of a relationship doesn't apply, but it may only now apply to principal residences.
Okay.
Are you going to transfer before next Tuesday?
No.
Okay, then I'll give you the answer properly next Tuesday. All right?
Maria, there you go. David's taking that as homework. David, what about if you transfer ownership within a family but not within a relationship? So, say, father to daughter.
A stamp duty.
Stamp duty.
Stamp duty. There are exemptions.
So there's always stamp duty, it seems.
Well,
it's such a lot of money.
Well, yes. Well, one of the suggestions, there's an interesting, they're reducing stamp duty in New South Wales but increasing land tax.
Yes. Well, and in some places you can choose. Do you want to pay the stamp duty up front, or do you want to pay a higher rate of land tax?
Land tax, yes. So then we'll start getting land tax on homes. So At the moment, you don't pay land tax on your
On your-
principal residence.
Right, and you would if
And
you
you
had,
would if this process came in, yes.
which would be more lucrative for the government.
Over the longer term, yes, there's a short-term cost for the government, but a longer-term gain.
Mary in Ballin. Good morning, Mary.
Oh, good morning.
She's clearly never been to Balan, has she?
Oh, sorry.
Clearly not.
Oh, Mary, I'm sorry.
Yes,
It's all right.
yes.
I'm putting it on my list of places to go to and learn how to pronounce.
And go via Wallen, if you
Okay,
like.
I know how to pronounce Wallen.
Yep. Hi, far away, Mary.
We're one of the small businesses that everyone's been talking about, really badly affected by the COVID-19 and the lockdowns. We've been renting the same factory for 7 years, and we weren't prepared to sign a lease for another 5 years in the middle of the...
In the middle of COVID. Quite
in
understand.
the middle of COVID.
Yep.
Yeah.
I mean, I
And-
signed a new lease the November before COVID.
Right.
So, you have good, you do good deals and bad deals in life.
Yes, you do. So, kicking and screaming, we got the 50% rent relief.
Yes.
But much to my surprise, late last year, there were all these requests for the insurance man had to come through and this one had to come through. And it turned out that it actually advertised the factory for rent.
Yes.
And they have successfully leased it. So we got a notice just after we paid the rent on the 16th of June.
Saying that your lease was coming to an end. Yep.
Our lease was coming to an end on the 26th of July.
Yes.
Now, we're a printing company and we have tons and tons of equipment.
Yep.
And anyway, my question is, they've issued us the bill for the owner's corporation fee, which goes from April through to the end of September.
Mary, you pay up to the day you're leaving.
Pro rata.
Yes.
So I do.
So in a sense, it's like a property transaction. You adjust rates and outgoings, the expenses you're required to pay under the lease, up to the date of the end of the lease. Now, the normal practice is you would pay those expenses on your last day. So if you were leaving the premises on the 26th of July, you would
Yes.
normally pay rates and your outgoings and your insurance and your owner's corporation for the 26th as well.
Okay. Thank you very much.
Pleasure.
Thanks, Mary. Jared in Mount Waverley. Hi, Jared.
Hi, good morning, everybody. I am a beneficiary of a will left by a friend of mine, and which is administered by the state trustees. Last year they contacted me saying that I was a beneficiary. Since then, I asked to get a copy of the will. So I've got 3 questions. Am I entitled to get a copy of the will? And how long does it take to resolve this type of issue?
Okay. As a beneficiary, you are entitled to a copy of the will. There's a specific provision in the Wills Act, Section 50, which says that you can have a copy. So you ask them, you quote Section 50, you ask for a copy. The law does say that you can be required to pay for the provision of the copy, but I would have thought the processing of a $5 invoice would cost them more than $5, so I wouldn't expect that you would pay. How long does it take? They write to you and tell you that you're a beneficiary. You can look at the Supreme Court website, supremecourt.vic.gov.au. On the right-hand side, look under Wills and Probate, and you can see, by doing a search, when they got probate. Now, you would expect, so they get probate, they then advertise for creditors. I would have thought between 6 and 9 months from the date of the grant of probate.
It's got to be at least 6 months, doesn't it?
There's 3 thresholds. The first is that an executor can advertise under Section 33 of the Trustee Act that says, if you're a creditor or you're making a claim, come out and tell me. And if you don't tell me within the 60-day notice period, I'm entitled to distribute the estate without talking to you, without following up. The second is if an eligible person, and they're people who have the right to bring a claim against your estate, not as a creditor but as the deceased should have made adequate provision for me and failed, you've got 6 months from the date of the grant of probate, and that can be extended for another 2 months. So, that's 6 or 8 months there. And there's also an old common law concept called an executor's year, and that is you can't complain if the executor takes 12 months to administer the estate.
But you can if it's 14 months.
Well, and the real question is, well, why? So I've got a rather large estate at the moment where I'm waiting for a private ruling from the tax office before I will finish the administration of the estate.
How long have you been waiting, David?
Oh, not long at all.
Not long.
6 or 8 weeks. But we could be talking about $3 or $4 million in capital gains tax. So you can imagine I'm not keen to pass it on until I get the right answer.
No, I can completely understand that. Good luck, Jared. Ray in East Doncaster. Hi, Ray.
Good morning. How are you both?
Good, thanks.
Good, thank you. I have an interesting problem concerning Bodies Corporate. I am an owner in a body corporate in Doncaster East of about 78, 80 properties, and it runs as it does. It has a committee. The committee is now we are not allowed to contact any member of the committee directly, and I find that galling because one can't talk to a committee member about a problem.
So do you know who they are but you can't contact them, or you don't know who they are?
Because I know when they were elected, but we're not allowed to contact them.
I just don't see that, Ray. I can't see that it would be a valid rule for you not to raise a concern you have in relation to the Owners Corporation with another member of the Owners Corporation, whether they be committee or not. Now, it may well be that they come along and say that we will only accept at committee meetings material that comes to us, and so they don't want you to be the committee member to be a conduit to the committee meetings. But I can see no law that would prevent you talking to another member of the Owners Corporation.
Okay, thank you. The second problem is that when this complex was built, it has a supermarket beneath it, and the developer has maintained that supermarket and a car park beneath it, and there are 3 other residential commercial properties.
Yes.
Yeah.
My question is it lawful for a developer to maintain such a proportion of the thing for commercial purposes?
They will have received.
Complex,
they will have
so
received.
That he has a disproportionate share of the votes.
They will be paying a bucket load more in rent than you will, if that matters, Ray.
You need about liabilities.
You need to look at the Owners Corporation rules and the plan of subdivision to find out who has what entitlement and what liability. So I can remember an Owners Corporation in Swanson Street where the old dental hospital was. They had an Owners Corporation that owned the building, they had an Owners Corporation that looked after the retail, and they had an Owners Corporation that looked after the residential. So, for example, they didn't ask the retail tenants to pay for the lifts that only serviced the upper floors. So have a look. How long have you been there, Ray?
3 years now.
Then go back to your solicitor or conveyancer and get a copy of the plan of subdivision, and that will include unit liability and entitlement, and probably multiple plans of subdivision, multiple owners corporations, and work out whether it's being run the way you want it run.
It should all be laid out there. Elizabeth in Melton. Hi, Elizabeth.
Oh, good morning, David and Ali. Excuse me. My question is with regard to FVIOs, Family Violence Intervention Orders.
Yes.
Is there a screening process to ensure the claimant is mentally fit to lodge an order?
No.
So, that's depressing, David, that answer.
Well, what you go along and you make I have real sympathy for the Magistrates Court at the moment because of the delay in them being able to handle these. I have a client against whom an order was made last November. The matter's listed in the middle of August for 5 minutes. So, and in that period of time, interim orders have been made. So what happens is that you make an appointment to see a registrar at the Magistrates Court. You give them the information, and sometimes the police will support you with this, and sometimes you do it on your own. And the registrar will or will not make an interim order on the basis of the information that you present or that is presented. So there'll be an interim order made on one person's say-so, and that's because we regard the safety of a claimant to be of prime importance while we worry about... but then there'll be no orders made against you that involves a finding by the court.
Yes, I've been through that process quite recently.
Yes.
And was successful with challenging the intervention order. A 2-year time period was put on the person, the claimant.
Yes.
That she has to stay away from me. Look, it's mental illness that's the problem here, and I don't want to say somebody's mentally ill without any qualifications, but it just distresses me that it's not a family member, but a close family member.
Yes.
Many years. It has definitely signs of Wernicke-Korsakoff. Have you heard of that one?
No. But
it's
look, Elizabeth,
long-term.
Elizabeth, the difficulty would be is that people with a mental illness have the same rights as you and I do, as a starting proposition. So to turn around and say, well, I'm not going to let someone with a mental illness bring a claim until I'm satisfied. How do I test whether they are appropriate to bring an application or not without letting them bring the application and then do the testing? I think the problem is really that the pressure that the court system is under at the moment is such that they're not in a position to deal with these in a timely manner. You're waiting months and months and months and months.
Elizabeth, we wish you well with that challenge. Barbara in Hawthorne. Hi, Barbara.
Oh, hello, Ali, and hello, David. My problem is I'm having trouble getting a copy of a promised warranty for some tiling on my terrace, and it's over a month since it was finished, and I paid within the week. It was over $20,000, and I haven't received a receipt or the promised warranty, which was supposed to be 15 years.
Do you have an invoice, Barbara?
Yes, I do.
Okay,
yes.
So and you've got evidence of payment. I don't know that anybody sends out receipts these days. Do they? You pay your gas, your electricity, your telephone, whatever your newsagent, whatever you pay, they just say thank you very much.
But does that mean that if there's a problem, Barbara can use her invoice that she's paid as proof of work done and use that to go back to the person who did the work to fix it? The
difficulty from Barbara's point of view is she's looking for a piece of paper that gives her certain rights. Have you got advertising material that talks about a 15-year warranty?
Nothing. No, it was all verbal before the work was done that I would get a warranty.
Yes.
A warranty for the waterproofing of the terrace. I'm up high.
Yep.
And an 8-year warranty for the actual tiling work.
Yes.
And that was good. I was,
Is
pleased.
that in an email or is it all verbal?
No, it was verbal. It was all verbal.
I feel very sorry for you, Barbara. But there's...
I'd keep trying though, Barbara. It's only a week. Keep trying. You never know. It still might come.
Do they have commercial premises? Do they, or is it?
Yes, they do. But there's only one phone number, and that's the phone number of the man, like the tiler.
Yes.
There's no phone number from the premises, but they do have an address.
Then why would you not go and ask at the premises?
Well, that's what
next.
I think that's what I've got to do.
Okay.
But I've emailed 3 times and there's been no response. All right, well, thank you. I could do that.
Good luck, Barbara.
Okay.
I also think, though, if it's a fellow who's running his own business and he's tiling at the same time, you might find a week's not long enough to get him to get his paperwork in order. You never know.
But if you've got a business that offers a warranty, would you not have the warranties pre-printed?
No, too true. Ron in Geelong. Good morning, Ron.
Ron, before we talk to you, if Barbara's still listening, there could well be a manufacturer's warranty on the membrane, and there could also be a manufacturer's warranty on the tile.
Well, there you go. That's something to ask, particularly if you get in contact with the tiler. Ron, you're on.
Yes, David, it's about a will. we made wills quite a few years ago, and the solicitor had them in his safekeeping.
Yes.
But he's now shut up shop. 2 or 3 years ago, he shut up and completely gone, and we don't know where all these documents have gone.
There's two places that you can ring, Ron. I don't know you'll get the answer on the phone, but you will get an answer. The Legal Services Board, Legal Services, lsbc.vic.gov.au, and you can ask LSBC, Legal Services Board and Commissioner, .vic.gov.au, should be able to tell you who has the records of the lawyer.
Yep.
And the other place that you should consider talking to is the Law Institute, which is liv.asn.au. Send them emails, tell them the solicitor not the solicitor, but the name of the firm. So the last time the firm was in practice. Is it in Geelong?
Yes,
Then why I would probably ring a couple of the bigger firms or firms in the immediate geographical area and see if they might have them. Okay?
Okay, no, we completely just shut up shop.
No, I understand that, but there is a requirement under the legislation that you do something with your records, particularly when you're holding titles and other things. So I try the neighbourhood, and try Legal Services Board, and try the Law Institute.
David Whiting is with us, giving you free legal advice. 1300 222 774 is the number. John's joined us from Warrandyte. Good morning. Where are you, John? Good morning, John.
Yes, and good morning to you both. Just a quick one. In January this year, I purchased a water pump, cost in excess of $500. After a couple of months' use in April, it failed, and the company has replaced it. The pump has failed again, and in June, so 6 months since date of purchase, 2 months since the most recent replacement.
Yes.
I'm just concerned that this pump, if it's failed now twice within 6 months...
Well, they're different pumps though, aren't they, John?
Correct.
Yes.
They are. They did a complete replacement with the new model, because they've superseded the old model. I'm just worried that this might be an ongoing issue. The pump has a 12-month warranty. Where do I stand as far as my beliefs that this might not be a durable product?
The ACCC is of the view that if you've got a replacement, if you get new for old, you should get the same warranty again.
Another 12 months?
Yes.
Right.
So in the event, I'd probably do some Googling to see if there is any indication of long-term problems with the pump that you've got.
Well, it's failed again.
I understand.
Yes.
But if I make 1 million pumps a year and 2 of them fail and I sell them both to John from Warrandyte, it doesn't mean that all of the other pumps are faulty. I'm suggesting that what you're looking for is an indication whether the brand and model of the pump that you've got has some inherent problems, which would make an application either to the manufacturer or to VCAT for a refund a better outcome.
Yes, thank you.
All right.
Good luck with that. David, you might be interested in this. I'm not sure whether you're a Grand Prix fan, but...
I went once.
Oh, did you?
Yes.
Before COVID?
Oh, long before COVID.
Did you like it?
Very noisy, and I had a friend who had a boat on the lake. So I think it was the first one. Haven't been back.
Right, okay, that probably says something. Well, Channel 10 and Channel 7 are both reporting that the Grand Prix is going to be cancelled this year. It was meant to happen in November. I think it was the 19th of November from memory. It was when it was due to start. Of course, we know when all of this kicked off, the pandemic, at the beginning of last year. It was cancelled at the last minute. But we also know that the Grand Prix put a whole sort of safety plan to the government a couple of weeks ago, and it was under consideration. Now Dan Andrews is expected to give a media conference around 10:30 this morning, which is actually just in a couple of minutes. So we'll keep you up to date. We have contacted the Australian Grand Prix Corporation, so we can't confirm that, but thought you might be interested in the fact that it is being reported. There you go, David. So if you did want to go, if you did want to go, you can't. I'm sorry. David Whiting there. Thank you, David. We will see you next week.